All right, and so we're here on Mr. McEachin's 4 cases, 21 CR, 61, 63, 62, and 60. Mr. Johnston.
Thank you, Your Honor. Shane had an eval, drug and alcohol evaluation on earlier this month on July 8th. That report has now been completed. However, I have not yet gotten it. I'm supposed to get it later today. I'd like to get the county attorney a copy of that. We've been expecting it. So I'd just like to ask you to pass this 1 week and hopefully we'll have some direction at that time.
Ms. Beverland, any objection? All right, so we will continue this for 1 week until the 28th at 11 a.m.
Thank you, Your Honor.
All right, thank you, and good luck to you, Mr. McEachin.
Thank you.
And next, we have Mr. Fanning.
Yes.
Mr. Fanning, thank you. All right, and they've just gone to get your client.
All right. Who's Alyssa Spurga?
Spurgeon?
Spurgeon.
She's the court services officer.
Okay, thank you. I probably should know that.
All right,
No, it's all metal.
this is Mr. Fanning.
Oh, this is Quinn.
This is Quinn.
Oh, okay. No, we needed Mr. Fanning next. His attorney's here.
Fanning, the one that was in the zone.
Okay. All right.
call. Oh dear. I'm sorry. I didn't mean to be calling you right now.
All right, and this is Mr. Fanning.
Yes.
Okay, so this is case number 2021 CR 77, State versus Jacoby Fanning, who's here via Zoom with counsel Elaine Esparza. Ms. Esparza, this is a first appearance. Have you had a chance to talk to your client about the charges?
We've spoken over the phone, and I have sent him a letter with discovery. Did you get that, Mr. Fanning?
Yes, ma'am, I did.
Okay. I think we're ready for first appearance, Judge. I thought this was just a docket call. But Mr. Fanning, at first appearance, the judge is going to tell you what you're charged with. Do you understand the charges?
Yes, ma'am, I do.
Then you can waive a formal arraignment, and that would be an actual reading of the complaint, or a formal reading of the complaint. We're not at arraignment yet. Do you understand it? No.
Do you understand what you've been
You try,
charged?
Judge.
No, that's okay. Do you understand, Mr. Fanning, do you understand what you've been charged with and the possible penalties, or do I need to explain those to you?
I understand the charges and the penalty.
Okay.
So,
So if you want to, I can go over those with you again. But if you already understand them, you can waive formal reading, and I don't have to read them to you.
I'll waive formal reading then.
Okay. Thank you. And so, Ms. You do understand you have the right to have a trial on this matter where the state has to prove beyond a reasonable doubt. And that you committed each and every one of these offenses, and you have an attorney. So, Ms. Esparza, how would you like to proceed?
Well, the first thing I'd like to do, Judge, is ask for a reduction in bond. I couldn't find my notes, but I believe bond's already at $50,000 cash or professional surety. And I would actually ask that this be reduced to $2,500 cash or professional surety. These offenses allegedly occurred back in August, I believe, of 2020. And we are at August, well, almost to August of 2021. And these charges weren't filed until July 5th. So for the last year, Mr. Fanning has had no run-ins with the law at all. I don't know if he even knew the charges were a possibility out there, but he's I believe, a lifelong resident of the area. He doesn't have the funds to flee, doesn't have a passport, and I'm not even certain that he has a car. We don't believe he's a flight risk, and we don't believe that he's a risk to society. I think he has shown that in the last year. It's always easier and in a case this serious, it's always easier to consult with your client if he's out. And one final point, Judge, Mr. Fanning had even been accepted into the Army until this came up. So I think that also speaks to his good character, and that he would not be a risk if he could be released on the $2,500 cash professional surety bond.
All right. And Ms. Beverlin, what's your position?
Ready?
Yes.
Just to address, of course, we've all been through COVID, and there's been a couple of people who sat in jail during the pandemic awaiting jury trials. We're just now at a point that we're scheduling jury trials. So that is something that affected the filing of this case even after the investigation was complete. So that was something that was considered by me. The courts are back open. We're now processing and moving cases how they should be. I don't disagree. I don't think this individual is really a flight risk. I understand he is a lifelong resident. But as far as the severity of the offenses, I think $2,500 would be too low. $200,000, I think, which is where it's at right now. I don't foresee him being able to post that. Not many people can. I would be agreeable to some sort of lower bonds with some sort of bond reporting and supervision because of the type of the offense, no contact with victims or witnesses. But $2,500 does seem a little low for the type of offenses that we have. Thank you.
And what's his bond set at? Is it 50,000 or 200,000?
No, 200,000. 20,000 to do 10% of 200,000.
So it's 200,000, Judge.
Yes, ma'am.
Yes. Okay, and Mrs. Sparza, would you like to respond to that?
Judge, it's my understanding, I'm not sure what Mr. Fanning's employment was, but prior to this, he's a young man. Generally, they don't have a lot of financial resources. I can understand Ms. Beverlin's position that it's too low, 2,500, but we'd like it set at some reasonable amount that he would be able to make.
All right. And these are not, these victims don't live in the same household or anything.
No, Judge.
And he does have a place to live.
Yes, sir. I believe he'd be residing with his parents.
Yes, ma'am.
All right. Okay, and Mr. Fanning, these are very serious charges that you're facing, and I hope you understand that. I am willing to lower your bond, and I'm going to lower it substantially, but I'm not going to lower it to $2,500 because I understand you're not a flight risk, but there's also the safety of the community to think about, especially the two alleged victims in this case. And so I tell you what, I'm going to lower your bond to 25,000 cash or surety, which is almost 10 times what it was, lower than what it was. And but I'm going to order that if you do make bond, that you're to have no contact with any witnesses or victims in this case. Anybody that's listed as a witness, you're to have no contact with them. And when I mean no contact, I mean you see them at Walmart and wave at them. Don't do that. I mean, you stay away. I mean, absolutely no contact.
That's
And
understandable.
then I also am going to require that you report to pretrial services. If you make bond, get out of jail, you need to come and sign up with our court services officer. And then you need to abide by any conditions that is set by, that's required of your court services officer.
Can you repeat that, sir? I didn't quite get that.
You need to abide by any conditions set by the court services officer. If you get out of jail, you have to come over and you have to sign up. Basically, it's a pretrial probation. You have to report to court services. And in addition to the no contact order, that your court services officer may impose other conditions on you.
Okay, sir. That's understandable, sir.
All right.
Yes, sir.
And
Ms. Beverlin, you're muted.
yeah, and okay, hold on. I've got to yeah, now you can go ahead.
I was just gonna ask for A&D authority, if in fact he has contact with the victims or witnesses, that the CSO has discretion to do an A&D.
Did you hear that, Mrs. Sparza?
Yes, I did, Judge.
Okay,
I'm sure that my client does not understand what an A&D is.
okay,
Do you?
No,
Okay. What that means, if the court services officer believes she has cause to believe you have violated the terms of your bond, she can do an affidavit to arrest and detain you.
So another warrant, pretty much.
Pretty much, you'd be taken into custody.
all right.
I understand.
And what that means, Mr. Fanning, is that, and I am going to grant this, and that gives the court services officer basically the power to arrest and detain you without coming to me and having me sign a warrant. Okay.
Then that's fine.
Usually,
fine,
yeah,
sir.
usually it takes a judge to sign an arrest warrant, but in this case, the court services officer could have you arrested without a warrant.
Okay.
Okay,
So,
and that would happen if you had any contact with any victims or witnesses, as long as you abide by the conditions of your bond. It's not something that you have to worry about, but in this case, I want her to have that power, just so you'll know that any violation of this is going to end it, and it's going to land you back in jail.
yes, sir. That's understandable, sir.
All right. Okay, and so that's granted. So, Mrs. Barza, what's the next step in this?
Well, we need to set it for a docket call, I believe, Judge.
Okay,
My problem is, I'm going to be on vacation. I will not be back and available until really the week of the 16th. So
I'm assuming you're going to waive the 14-day preliminary hearing.
yes,
Okay,
I haven't had a chance to speak with Mr. Fanning yet, so I need to do that before we decide whether or not we're going to set it for a preliminary hearing.
okay. All right, so we will, Ms. Beverlin, do you have any objection to continue this? So we'll continue this until August 18th.
All right,
And so
and
docket call on August 18th.
will that be at 10 o'clock?
Yes, she waived the 14 days. Yes, well, okay, so that will be at 10 o'clock if he makes bond. if he's still in jail, it'll be at 11 o'clock.
Okay, I have a sync hearing at 11 o'clock. I was out today in 10 minutes, so hopefully I'll be able to join you
Okay.
Shortly after 11.
Okay. But if he makes bond, that will be at 10 a.m.
All right.
Okay.
Yes.
Anything further?
Well, Mr. Fanning, do you believe you're going to be able to make bond?
If I can get the amount of the bond of what it's going to be again, real quick, I can see.
2,500.
2,500.
That's not right. 25,000. Your bond is set at 25,000.
Bond says. I should be able to. It should take maybe a couple of weeks or so, but I should be able to bond it out.
All right.
I'll call my parents after this to.
All right. Well, I've got court in Kingman County, so I'm going to try to come over and see you this afternoon.
Okay.
So I just wanted to make sure you were still going to be there.
Yes,
All
ma'am.
right,
I'll be here
Judge.
for at least for a couple of days.
I don't have anything else. Thank you.
Okay. Thank you very much. Mr. Vang, we'll see you in a few weeks. Okay, so now if we can get Mr. Phi next.
Okay.
Mr. Phi, and then
Should I bring your glasses?
I can't find them. I don't know where they're at.
Mr. Phi?
Yes, sir.
All right. I'm letting your attorney in. And then Mr. Howard. We're letting Mr. Howard in. There he is. And Mr. Howard, you're here for Mr. Phi, is that correct?
Yes, Your Honor.
All right, and this is 2021 CR 59. Welcome back, Mr. Howard. What do we need to take up with Mr. Phi today?
Your Honor, in this matter, we do have a prelim previously set for August 18th. I do think in this matter, we're trying to see about some negotiations, but we'll haven't got anything taken care of at this point regarding that. I would ask in regards to this matter, Mr. Phi previously had a treatment bed set up. As this court's aware, he was released an OR bond prior to being picked up in Oklahoma on separate charges there. He was released on a PR bond, which is my understanding is Oklahoma's equivalent of an OR bond, and returned back to the custody of Pratt County. As he has already had an evaluation, Your Honor, I would ask the court to consider ask whether the court would consider should we be able to obtain a new bed date with him, which I believe we should be able to get a new bed date set for him, the possibility of releasing him to be transported directly by the sheriff's office to treatment on the date of treatment at some point in the future once we get that bed date established.
All right, thank you. Ms. Beverlin?
Mr. Phi had a really big chance with an OR bonds. He not only complied with those requirements, but he picked up new felony charges in the state of Oklahoma. I don't think he's a candidate at this point for any sort of modification to go to treatments. If I get an eval and take a look at it, maybe I might reconsider my opinion, but with what's happened and what he's already been given, I just don't think he's a candidate for it at this time. Thank you.
Can he get an evaluation in jail?
Your Honor, he's already had an evaluation. He had an evaluation prior to his release, and we had a bed date set up for him. I can see about if Mr. Phi doesn't have an objection, getting that evaluation and providing that to the court in regards to this matter or to the state. But he's already actually had the evaluation. He had a bed date set up for July 7th. Unfortunately, he was still in custody in Oklahoma at that time, Your Honor. As he is back now, I guess at this point, it simply would be just getting a new bed date set up if the court get him a bed date set for him to go. And I guess I believe everyone else was seeing, in my understanding, DECA can go ahead and get him on the list for a bed date. So at this point, it's not really a matter of getting an eval, but just whether the court will permit him to be released to that treatment. I don't want to get a bed date if he's if he's not gonna be able to make it.
I mean, will his eval still be valid since, I mean, when he tested positive for meth while he was out, apparently, allegedly, according to the supplemental affidavit filed by Ms. Spurgeon. He continued to do drugs while he was out. I mean, is that going to affect his, at this point, I understand what Ms. Beverlin's saying, that could affect his ability to get, to qualify for treatment.
Your Honor, I'm not sure how it would affect his ability to qualify for treatment. His treatment recommendation was for inpatient treatment. And Your Honor, I mean, I can check to clarify, but my understanding is that he would be, his evaluation would still qualify, and he would still be able to use that evaluation to get himself to get into treatment. So I can check with DECA to confirm that, but Your Honor, I don't believe it would impair it, particularly as his prior recommendation already was for inpatient treatment.
I know my wife called, Your Honor, this is Caleb. My wife called DECA. I called her from my cell in here. My wife had called DECA prior to this court hearing, and the receptionist at DECA here in Pratt said all she would have to do was call the treatment center itself to see if that bed date would have been held for a certain period of time. So I don't really know what will happen with that. My wife never got a call back. But I know I've signed all kinds of releases of information for the lawyer and all that.
I understand. Why don't we continue this 1 week and see where we are next? And Mr. Howard, see if you see what the availability of the bed. I mean, I just know that with the waiting lists that they have, they're not going to get him a bed in a week. But see if you can come back next week with a specific date. I mean, if he does still go to treatment, and if they will still take him, that's what he's going to have to go directly to inpatient treatment and not be able to check himself out.
Right.
But I want some assurance that he's going to have it. So let's just continue this 1 week and let's see where we are.
Okay.
And so we'll set this for 11 o'clock on July 28th.
That sounds good, Your Honor. I will get with DECA and see if we can get a bed date scheduled for him and go from there.
Okay, thank you. Okay, and now we're ready for Mr. Quinn.
And Your Honor, I believe that's all I have on the 11 o'clock.
It is, thank you. All right, and you're Brandon Quinn?
Yes, sir.
Mr. Quinn, you're here today. There's been an affidavit filed by the Pratt Police Department that in support of your arrest that claims that you may have committed aggravated assault and criminal threat, which are felonies, and could, if you were charged with this and convicted of these crimes, could land you in the state penitentiary and a hefty fine. According to the affidavit from Sergeant Ferbert, you went to Walmart with a knife and threatened some folks in Walmart, actually threatened to kill somebody and drew a knife on them. Do you understand why you've been arrested?
Yes, sir. And
okay, hold on just a moment. Now, you do have the right to have an attorney. Charges have not been filed yet, so there's currently no case against you, but you do have the right to have an attorney. And I have here that you've filed a financial affidavit and an application for a court-appointed attorney. Did you fill this out and sign it?
Yes, sir, I did.
Okay. And so based on the income that you're claiming and your expenses, I'm going to find that you do qualify for a court-appointed attorney, and I'm going to appoint Robert Slinkard to represent you.
Yes, sir.
And then we will send you his contact information, and you'll be able to contact him and talk to him about your situation. Now, Ms. Beverland, who's the county attorney, is here today, and I'm going to ask Ms. Beverland what the status of this case is.
I've got an initial review of it. I can have a complaint filed by Friday, Monday more likely, with the charges. He's looking at 2-person felonies for sure.
Okay. Well, Ms. Beverland is pretty, and I don't know whether you heard that or not, but so Ms. Beverland says she does plan on filing a complaint with 2-person felonies, probably by the end of the week or early next week. What I'm going to do is set you for another hearing on next Wednesday at, it'll be at 10 o'clock. If you end up making bond, it'll be 11 o'clock if you're still in jail. And now you have an attorney, and then you'll make a first appearance on that next week.
Yes, sir. Is there any way that I could ask for an OR bond, or at the very least to drop my bond to get out of here? Because I have a job waiting for me. I have a girlfriend that's taking care of all my bills right now. We've actually gone into debt because of this in the last few days. All my bills came up in just the last few days, and I need to get out to get to my job before I lose it.
And what's your bond currently set at?
At $10,000.
Okay, Ms. Beverland, I don't know whether you want to unmute and talk. Do you have what's your position?
Judge, I think bond is appropriate as said. I believe the victim has now also filed a PFA against Mr. Quinn. I don't know if that's been served or not. It's my understanding that there had been incidents in the days prior with whether or not a handgun was being brandished or not. The details I'm not quite clear, but I do know that there had been issues preceding this ultimate events where the knife was brandished. Mr. Quinn is a criminal history C, so there's some history behind him. I think really it's the public safety argument at this point. I at this time, I don't think he's a flight risk because I have not dug into his III yet. But he's got some priors, Judge, felonies and person offenses as well. So I think bond has said it's more than appropriate. Thank you.
Okay, and Mr. Quinn, you will get a chance to respond. Which you may do at this point.
Yes, sir. It's been almost 7 years since I've been in any trouble. I mean, I've gotten a traffic ticket here recently. It was the only thing that I've done for 7 years. And one of the reasons I'd like to get out to do this is that there should be video footage of the cases in mention to actually go for my case in this particular matter that Officer Ferber said that he was supposed to have acquired. That video footage should more than well prove the fact that I did not actually just outright threaten anybody with a knife. Not to mention there's supposed to be a case filed against the property or the persons in question here for them pulling a firearm on me the night before this even happened at Walmart. Mr. Ferber was supposed to file a report for that and file it into the court. That's why I even pulled the knife out in Walmart.
Okay, well, before you get too much into the case, I want you to understand this is a public hearing. The prosecutor's here, and you might say something that further incriminates you on this case. And I think under the circumstances and with the charges you're facing, I think that $10,000 cash surety is a pretty reasonable bond. So I'm going to leave it at that at this point, but you can certainly talk to your attorney, and if your attorney can, your attorney might file another motion to modify bond or be able to convince Ms. Beverland to agree to bond reduction, certainly. But if I were you, and plus anything that you talk to your attorney about will be privileged. And of course wouldn't incriminate you.
Yes, sir. Is there any way we could drop it just to 7,500 at the very least? I know you said that you think it's appropriate. We're really tight on money and I do need to get to my job. That's my main concern right now.
Okay,
I just don't feel right leaving my girlfriend out there alone, taking care of all my bills. And I'll be put on house arrest, whatever you need to do to make sure. There's already a PFF put against me and the parties in question. I'm not going to go around them. I don't want to go around them. I just need to get to my job.
Okay, well, it is set now with a surety, so you could get a surety. I'm going to leave it where it is right now because of the seriousness of the charges, and I understand that you don't want to be in contact with these people anymore, but I'm kind of concerned about the safety of the community under these reports, and so but you talk to your attorney, and we'll plan on seeing you next week.
Yes, sir. When should I be in contact with him?
We will get you his contact information as soon as we can, and then you can call him there from the jail.
All right, thank you, sir.
All right, thank you. And I believe that's everybody.
Awesome. Thank you, sir.
Thank you.